Hello, my name is Alex Proctor. I'm the Chief Trust and Privacy Officer at Captain Compliance. I'm publishing this video on the last day of June in 2025. Tennessee's brand new data privacy law is going into effect tomorrow. If you're a business that operates in the state of Tennessee, this is a big deal, so I'm going to do my best to share everything that you need to know about this law. The Tennessee Information Protection Act, or TIPA as I'm going to call it from here on out, was passed in July of 2023. Like many of these new state laws, TIPA's formal enactment was delayed by a couple of years so that businesses could have time to prepare and adjust their privacy practices. Depending on exactly how you count, this is something like the 14th comprehensive state privacy law to go into effect so far. In fact, it's the 6th of 8 state laws scheduled to go live this year alone. We're really in the heat of it right now. TIPA is designed to protect residents of Tennessee acting in an individual or household context. It gives Tennesseans certain rights relating to their personal data and creates additional mandates for companies, including both controllers and processors of personal information. Under the law, you can think of a controller as the business that controls the personal data and determines how it's to be processed. In contrast, a processor would be an entity that processes data on a controller's behalf and in accordance with the controller's instructions. TIPA defines personal information as information that is linked or reasonably linkable to an identified or identifiable natural person. It does not include information that is publicly available information or de-identified or aggregated consumer information. That second half of the definition was important because it may bring some types of information processing out of scope for some businesses. TIPA also includes a definition for sensitive personal information, which can refer to data revealing racial or ethnic origin, religious beliefs, mental or physical health conditions, sexual orientation, citizenship or immigration status, genetic or biometric data, information about children, or precise geolocation data. The law imposes specific requirements when businesses process this type of sensitive information, including opt-in consent requirements. In contrast with some of the other state laws, TIPA leans towards being more business-friendly than consumer-friendly. One of the most obvious ways that this can be seen is with its tighter-than-average scope of applicability. In order for TIPA to apply to a business, the business first needs to exceed $25 million in annual revenue. This is already a pretty unique requirement. Most of the state laws don't have a pure revenue threshold like this. Instead, most of them focus more exclusively on the volume of consumer personal data that's processed. TIPA does include this as well. In addition to the $25 million revenue threshold, a business needs to control or process the personal information of at least 25,000 Tennessee consumers and derive 50% of gross annual revenue from the sale of that information. Alternatively, the law applies if a business meets the $25 million global revenue threshold while processing or controlling the personal information of at least 175,000 Tennessee consumers during the calendar year. Long story short, this law is going to apply to larger businesses that perform more personal data processing. This is in contrast with some states like Texas and Nebraska, which have passed privacy laws that really don't have any of these sorts of thresholds at all. It's also important to know that there's a few industries that have been exempted from this law. State agencies, financial institutions, healthcare entities subject to HIPAA, nonprofit organizations, and higher education institutions are all exempted from TIPA. This is generally because these categories of organizations already tend to be covered by various sector-specific privacy regulations already. There's also a very unique exemption for state-licensed insurance companies. Tennessee is the very first state to include this specific exception. Now, one of the most important aspects of these new comprehensive privacy laws is the fact that they each tend to give consumers a robust set of privacy rights. Tennessee's law grants several new privacy rights to state residents. These rights tend to be very similar to those that are already provided for under other states' privacy laws. Much like those other laws, TIPA requires businesses to respond to consumer requests within just 45 days, with the possibility of a one-time 45-day extension. Tennessee's first consumer right is the right to confirm. You'll also sometimes hear this referred to as a right to access. It really encompasses both concepts. The idea is that individuals have a right to confirm if a controller is processing their personal information, as well as a right to gain access to that information. The second right that this law gives to Tennesseans is the right to correct. Individuals have the right to correct inaccuracies in their personal information. Third, we have a right to delete certain personal information. There are a few exceptions here. For example, the controller is not necessarily required to delete aggregated or de-identified information, and there may be situations in which data must be retained for legal purposes. The fourth right is the right to portability. This means that consumers can request and obtain a copy of their personal information in a common and readily usable format. Fifth, consumers have the right to opt out of targeted advertising, profiling, or the sale of their personal information. This opt-out right is a very important one to understand in depth that has several different implications. Like all of the other US state privacy laws, TIPA operates under an opt-out model, with notable exceptions for sensitive data where opt-in consent is required. This stands in contrast with more stringent global privacy laws, such as the GDPR or e-privacy directive in Europe, which typically require opt-in consent across a broader range of data uses. Let's first discuss targeted advertising. Under TIPA, businesses are not prohibited from deploying targeted advertising cookies or scripts by default prior to obtaining user consent, so long as they offer a clear mechanism for opting out. That means that you can technically run targeted ads without first asking for explicit consent, as long as you're not processing sensitive personal data. With that said, it's important to recognize that other legal frameworks, such as state-level wiretapping laws, may still expose you to litigation risk if you're intercepting communication without consent. I cover that in more depth in a separate video on privacy litigation. The right to opt out also extends to profiling. TIPA defines profiling as a fully automated process by which the controller processes personal information to evaluate, analyze, or predict personal aspects relating to a consumer, including preferences, interests, behavior, location, movements, health, socioeconomic status, and political affiliation. This aligns with a broader push across these privacy regulations to give individuals more control over how automated decision-making impacts them, especially when those decisions could affect eligibility or access to services. TIPA also gives consumers the right to opt out of the sale of personal information, which it describes as the exchange of personal information for monetary consideration by the controller to a third party. This one has several important carve-outs. For instance, if you're sharing data with a processor acting on your behalf, that is not considered a sale. The same goes for sharing data with a third party in order to fulfill a product or service that the consumer requested. Transfers to corporate affiliates are also exempt. If a consumer has made their information publicly available, like posting it on social media without restricting the audience, that's not covered either. Finally, disclosures made as part of a merger, acquisition, bankruptcy, or similar transaction where a third party takes control of organizational assets are also not considered sales under this law. One thing that's important to understand is that Tennessee does not specifically require businesses to recognize universal opt-out mechanisms like Global Privacy Control or GPC. That's a notable difference compared to about half of the other state privacy laws, which do require businesses to honor these kinds of automated signals. This is one more way that this law is a little bit more business-friendly than some of its counterparts. With that said, if you're doing business in those other states, the path of least resistance is probably to support automated opt-outs everywhere, including Tennessee, because most organizations will already have to do so for other state requirements. In addition to creating a new set of consumer rights, Tennessee's new privacy law also creates operational requirements for businesses. The bulk of these obligations are most directly relevant to data controllers. One of TIPA's most important requirements is that it requires controllers to provide a reasonably accessible privacy notice. The notice needs to include many specific points of information. You can think of this as Tennessee residents having an additional consumer right, a right to know, with the privacy notice being the required mechanism to provide the information. According to TIPA, privacy notices need to describe the categories of personal information that a controller is processing, the purpose for said processing, the categories of personal information that are shared externally with third parties, and the specific categories of third parties with whom the personal information is shared. The law also requires businesses to provide instructions on how consumers can exercise their rights and also how they can submit appeals if they disagree with the controller's response to a request. The second of the controller requirements is that businesses must limit the collection of personal information to what is adequate, relevant, and reasonably necessary for the purpose of which data is processed. This is consistent with our other state laws. They all tend to include this concept of purpose and processing limits. The third requirement follows the same theme. It requires businesses not to process personal information for purposes beyond what is reasonably necessary to achieve the objectives for the processing, unless consumer consent is maintained. Fourth, we have data protection requirements. Controllers are required to establish, implement, and maintain administrative, technical, and physical data security practices. Just like most other privacy laws, this is a very high-level requirement, and it doesn't get prescriptive at all when it comes to cybersecurity. The fifth controller requirement is that controllers must not process personal information in violation of a state or federal law that prohibits discrimination against consumers. And the sixth is that if the controller seeks to process the sensitive data of a known child, it must do so in accordance with the Children's Online Privacy Protection Act, which has some separate requirements of its own. Another aspect of TIPA that controllers need to address is a requirement to perform data protection assessments before conducting certain types of processing activities. This is actually something that most state privacy laws do include. The assessment requirements tend to activate in situations in which the business is involved in data processing for the purpose of targeted advertising, profiling, or sale of personal data. Assessments are also required when a business processes sensitive personal data or processes data in a way that presents some sort of heightened risk of harm to consumers. I'm not sure why, but Tennessee's AG TIPA FAQ page barely mentions this data protection assessment requirement. I think this is a bit of an oversight and that they should probably update their page to make it more obvious about what controllers are obligated to do. Nevertheless, it is in the law and you do need to know about it. We should also address the fact that TIPA does place some requirements on processors. These are primarily designed to make sure that processors are supporting controllers in their compliance efforts. Processors are required to adhere to instructions outlined by the controller, assist them in meeting TIPA requirements, contribute to the fulfillment of consumer rights requests, and provide supporting information to the controller so that they can perform their data protection assessments. The law also requires that controllers and processors establish contracts with one another to help codify these responsibilities. Contracts should also address confidentiality of personal information, mechanisms to sanitize data at the appropriate time, and the need for potential flow-downs within subcontracting agreements. Now that we've addressed these requirements of TIPA, let's briefly address how it is to be enforced. Tennessee's TIPA is going to be enforced exclusively by the Tennessee Attorney General and Reporter. This is similar to the model in all other states that have passed laws, with the exception of California, which also happens to have a dedicated enforcement agency. Similar to most other states, TIPA does not have any sort of private right of action, which simply leaves it up to the Attorney General to pursue enforcement actions. The AG office will bring enforcement actions in situations where there is a reasonable cause to believe that a controller or processor is violating TIPA. Many of these inquiries will be spurred by consumer complaints. By the way, if you happen to be a Tennessee consumer and you want to exercise your rights, you can file complaints to Tennessee's Division of Consumer Affairs through an online portal, email address, or via physical mail. The law does include a non-sunsetting cure period, which will essentially provide businesses with a 60-day window in which to cure violations and avoid penalties. This is a very business-friendly and generous aspect of the law. Many of these laws have shorter cure periods that expire, or even a complete lack of cure periods at all. If a business is notified in writing about potential violations and then fails to cure those alleged violations, the Attorney General can penalize the business to the tune of $7,500 per violation, along with additional fees and costs. This is pretty much par for the course when it comes to these types of laws. $7,500 per violation is the most common penalty structure across all of the states. One thing that is very unique about TIPA is that it includes an affirmative defense. According to the law, if a controller or a processor can show that it creates, maintains, and compiles a written privacy policy program that conforms to the recent versions of the NIST privacy framework or comparable framework, while also providing for TIPA's consumer rights, then an organization can use the affirmative defense. This is actually really interesting. If you haven't heard of the NIST privacy framework, it's sort of like the lesser-known sibling of the wildly popular NIST cybersecurity framework. They're actually designed to interoperate with each other, although I will say the privacy framework hasn't been embraced to the degree that the cybersecurity framework has. Similar to the CSF, the privacy framework is a catalog of privacy outcomes across a couple of core categories, like identify, govern, control, communicate, and protect. The entire concept is a little bit odd to me personally, because the NIST material was specifically designed to be voluntary and flexible, describing outcomes rather than prescriptive controls or specific measures. It will be interesting to see how this affirmative defense concept ends up playing out, considering that it's primarily tied to such a high level and flexible framework. It will also be interesting to see what comparable frameworks are eventually deemed acceptable for the purpose of affirmative defense. Okay, that was my summary of TIPA. I hope you found it useful. If you need help making sure that your company is in compliance with the Tennessee Information Protection Act, Captain Compliance is ready and able to help you. Our cookie consent banners are fully customizable to match the design of your website, and they can also be set up to apply different policies to different visitors based on their region. For example, you might choose to apply an opt-out policy to Tennessee-based website visitors, while applying an opt-in policy to visitors from the European Union. Our dynamic privacy notice also has a localized and geographically targeted Tennessee supplement built in and ready to go. If you're an existing Captain Compliance customer, these are already being rolled out and made available in advance of this law going live. We're helping you keep up to date with all of these changes. If you need help, please feel free to visit our website. It's www.captaincompliance.com. I'll put a link as well as additional contact information in the video description. Thanks for watching.